We're here for the last presentation of today, la última presentación, by Giovanni Tuzet from the University of I said it before, Bocconi in Italy. It's our Italian afternoon here. He's going to be speaking on probatory ostension, which I hope sounds prettier in Spanish and Italian than it does in English. Giovanni studied law and philosophy in Turin and Paris, and he wrote his PhD thesis on Peirce's theory of inference. He is presently an associate professor of philosophy of law at Bocconi University in Milan, where he teaches economic analysis of law, legal argumentation. His areas of interest include things like epistemology, pragmatism, as any good student of Peirce would, argumentation theory, philosophy of law, and economic analysis of law.
Thank you very much.
So give us a fabulous kickoff, final last talk.
Hopefully. All right. Thanks a lot. I'm really honored to be here, to be among the speakers in this conference, really impressive conference. Thanks to the organizers, thanks to the audience, to the public, to you who are still here at this time of the day. As you understand, I will make my presentation in English. I'm not a native speaker, so forgive me for the bad things I'm going to say, the weird things I'm going to say from the point of view of the language. Now, I will basically follow the paper that was sent. There are also some slides, but they are just minimal. They just outline the presentation, the main point of the presentation. For the rest, I'm going to, basically follow the paper. Just a few words on the title. The title is a bit weird. Maybe I agree on this. I don't know. I thought that you have that word in English. Maybe it's not a common one, but well, the idea is to focus on the act of showing evidence in the context of juridical proof. And I call it ostension. I think it's the right word for that kind of act. I'm going to talk about it. And I'm trying to, kind of explore some territory of juridical proof and fact-finding, which is not, explored enough by the existing literature, I think. It's rather a neglected topic. Maybe it is neglected because it's not interesting. It's an aspect of juridical proof and fact-finding which is, of little interest. I think there are some interesting things to say about it, as I will try to do today. Another word of caution at the beginning. I'm not going to be normative. I'm not addressing normative problems. I'm not going to suggest practical solutions to practical problems. I'm trying to be theoretical. Theoretical and philosophical. Sorry for this if you expected from me some normative advice. Okay, so on probatory ostension. Now, in fact, the thesis about juridical evidence and proof and fact-finding that I'm going to present are two, not just one on ostension. They are the inference thesis and the ostension thesis. But while the first is, I think, well received and well discussed in the literature, the second thing is rather neglected. So I will concentrate more on the second, and that explains my shorter title, if you want. A more exhaustive title would be on probatory ostension and inference, of course. So the presentation discusses these two theses on juridical evidence, and the first one is a very simple one to understand. It's the idea that the process of juridical proof requires necessarily, this is an important qualifier, some inference. Okay, I think we all agree on this more or less. So in the process of juridical fact-finding, juridical evidence becomes the content of at least one inference performed by the parties or by the fact-finders, judges or jurors. It can be the content of a premise or the content of a conclusion in a different inference, but anyway, it's some part of the content of some inference performed in that context, right? According to the second thesis, more in particular, the idea is the following. The process of juridical proof typically, not necessarily, typically, requires some ostensive act. In this sense, the evidence consists in some element susceptible of being shown or exhibited or indicated to someone, the fact-finders, in a given context. As I said, I think that the first thesis is already well established and well received in the literature. The reason is very simple. It is hard to deny that evidence per se, evidentiary items alone, evidence per se does not prove anything. Okay? For probatory purposes, we need inferences and arguments constructed out of the evidentiary items that fit the admissibility requirement of the relevant context, etc. So I will concentrate rather on the second thesis. I will address the probatory role of ostension as a probatory act, the logical structure of this act, and some points that pertain to the pragmatics of evidence discourse, namely the role of indexicals and demonstratives in this kind of discourse. Notice, before going into details, notice in any case that in the fact-finding process, ostension comes first, before inference. Parties present fact-finders with pieces of evidence and then elaborate probatory arguments out of them. No probatory inference can be performed without an ostensive input. That's my starting intuition. Okay? Now, some words about the inference thesis. Let me start by quoting some well-known scholars who have written on evidence and the purpose of fact-finding. In a paper of 1984, which is still a quite interesting one, I think, William Twining defines evidence as, I quote, the means of proving or disproving facts, or of testing the truth of allegations of fact, in situations in which the triers of fact have no first-hand knowledge of the events or situations about which they have to decide what happened. I agree. And he contends, more broadly speaking, that evidence is, I'm quoting again, information from which further information is derived or inferred, inferred is the word that interests me here, in a variety of contexts for a variety of purposes. Right. Notice, so the connection between evidence as information, according to Twining, and the inferential processing of this kind of thing. In the relevant context, for the relevant purpose, further information is derived inferentially from the evidence presented as the subject matter of the ostensive act. Okay? As to the purpose of this kind of process, Twining claims that fact-finding is instrumental to adjudication. I think we can agree on this. We are not interested in the knowledge of the litigated facts per se. Fact-finding is performed in the sake of rectitude of decision, he says, or of substantive justice. And the true account of the facts is a necessary component of it, I agree. Other scholars have similar views. I'm not going to say more things on this. Now, if you agree on the fact that truth and justice are two important goals and one is instrumental to the other, I think that the only way we have to achieve those results or ends is by means of inference. Evidence alone, evidence by itself, doesn't prove anything, as I said. We start from evidentiary items, of course, and then we process them inferentially, and we draw conclusions as to the case in hand. Because, as I said, no evidence is sufficient by itself. per se. Evidence proves nothing by itself, nor does it yield verdicts. It must be, as I say in the slide, inferentialized. This is, again, maybe a weird word, but I think that the content is pretty clear. Okay. To quote again Ron Allen, as he puts it, when he says that evidence, I'm quoting him, does not announce its own implications, yeah, I say that it must be inferentialized. In fact, to be more precise, in order to move from evidence to verdict, more than that is needed. I think that 5 requirements at least must be satisfied, and you have them in the slide. First, evidence must be admissible, that's a legal requirement, according to the rules of the relevant legal system. Second, it must be presented to fact finders, that's the Ostension requirement. Third, it must be inferentialized, what I was saying, by parties and fact finders. Fourth, evidence must be assessed to determine its probative value. And fifth, fact finders need to consider whether the evidence, as it has been assessed, meets the relevant standard of proof. Okay? Notice that there is a difference between point 4 and point 5. They're not the same thing. Evidence assessment is a different issue than decision according to some standard. I think that Jordi this morning made this point in the discussion. Okay. So the inference thesis I'm trying to defend is that the process of juridical proof requires necessarily some kind of inference. What inferences? That's the next question. What inference? Well, the answer is any kind of them, but especially abductive inferences and inferences to the best explanation. I think it's the main thing from an inferential point of view in juridical proof and fact-finding. This is the case because usually, not always, but usually, the information at disposal is not complete. We just know a part of what we would like to know. We happen to have some evidence that points to certain inferential directions, often incompatible. So the evidence we usually have is the effect of certain unknown causes. Then it is processed as the content of one or more premises contributing to some conclusion about the causes that would explain the evidence. This is abduction, simply. This is abduction. From a logical point of view, this is abduction. So the inference that formulates an explanatory hypothesis, given some evidence. And when incompatible hypotheses are so formulated, we face factual ambiguity, again, to quote Ron Allen, and we must select the best explanation of the evidence we have. That's the cognitive task I think we have in these cases. But I think that there is room for other inferences. I don't think that fact-finding is only abductive or only inference to the best explanation. I think there are other inferential tools that are sometimes at least used. For instance, there is room for induction, of course. Every time you have a generalization, you have some kind of inductive inference that has elaborated this kind of generalization. So we can say that inductive generalizations are necessary to establish, if we want, the major premises of probatory arguments. This is something that Michele Tarufo has pointed out somehow in the previous lecture. William Twining, again, in particular, has discussed the topic of background generalizations, as you well know. He has claimed that they are necessary but dangerous, etc. I'm not going again into that thing. Indeed, sometimes we go from evidence to inference, and sometimes we go from inference to evidence, where evidence is the conclusion of some inference. For instance, confirming evidence of an already existing hypothesis is processed in this way. Once an explanatory hypothesis is formulated, the additional evidence that is found contributes to the best explanation of the case via some generalization supporting the conclusion. Here the evidence figures as the expected conclusion given the hypothesis and given the relevant generalization. Inference makes it expected, and ostension of a confirming evidence, in this case,
presents it to fact finders. Okay? There is room for deduction also. Maybe some of you might be surprised by this, but I think it's not that surprising. Of course, the explanation of evidence can hardly be deductive, given the incompleteness of information I was referring to before. But, for instance, the finding of a conclusive alibi can be put into deductive terms, can be, fairly put in that way. In the modus tollens form, for those of you who love logical vocabulary. Consider, for instance, the following situation. Imagine that we assume as minor premise of an inference that, given a testimony, the defendant is materially guilty of a robbery that took place in Milan on some day at a given time. And we also assume as major premise of the inference that, as you know, no human being can be at the same time in different places, okay? Then, inferentially, we would not expect to find the defendant in Rome on the same day at the same time. And if, to the contrary, conclusive evidence is found that the defendant was in Rome that day, that time, well, that evidence falsifies the starting hypothesis deductively. So you have deductive conclusion in that case, in the form of a modus tollens inference. So there's some role for deduction in some cases, I think. Okay. Now, before I move on to the Ostension thesis, which is, I think, maybe the most disputable part of my presentation, let me just add a couple of short comments on what I've been saying. First, I've used inferences and arguments, but I think that in order to be more precise, we should say that arguments are, in this context, public inferences, and they are on disputed facts. These are two important points if you want to be clear on what happens. They can be conceived, as I said, as public inferences in that they are performed before a certain audience and certainly have other dimensions than the logical one. In particular, they have a rhetorical dimension and a specific point, which is persuading the audience, that is, the fact finders, the jury or the court. On arguments as public inferences, consider this aspect of your everyday experience. It's a kind of analogy, but consider it. We need not make arguments in front of ourselves, properly speaking. If you are alone in your room and make an argument in a loud tone of voice with dramatic gestures and facial expressions, either you are preparing an argument that you will perform before others, or you have some mental troubles, I think, okay? So arguments, properly speaking, are public inferences, okay? Second comment, trivial but analytically true, arguments are about disputed points. We need not argue about what we agree upon. It's, it's a way of losing our time and energy, okay? Now, the Ostension thesis, okay? First, let me clarify what I'm going to say. I'm not going to discuss the topic of ostensive definitions, as philosophers call a certain kind of definition, okay? As the name makes clear, just a few words on ostensive definition, the act of ostensive definition consists in showing some item that indicates the meaning of a word or expression. For instance, if someone asks me, what do you mean by pencil? I say, well, this is a pencil, okay? I do not give a description of it. I just show an item that exemplifies the meaning of the word in question, okay? That is ostensive definition. That is called this way. It's called this way by philosophers. Ostensive definitions have some merits and some limits, of course. This is not the place to discuss them. Suffice it to say that, on the one hand, they were cherished by some of the logical positivists of the Vienna Circle who tried to use them to explain how our words and concepts connect to the world of empirically detectable things. That was the interesting part of it. But Wittgenstein, on the other hand, famously criticized the use of ostensive definitions, saying that, well, no ostensive act can convey any meaning unless it is part of an already established language game. That basically was the point. Then in the paper I have a part where I discuss Quine's views on ostension, but I'm not going to present this part here. Now, the ostension thesis, what I'm focusing on, does not concern the use of ostensive acts for definition purposes, but for probatory purposes. So I call it probatory ostension, okay? It concerns the use of ostension to support a factual claim in the fact-finding context, pointing at or indicating the evidence that justifies some such claim with some inferences that process the information shown, okay? If you agree that the process of juridical proof typically requires some ostensive act, you might agree with me on the conclusion that evidence itself consists in elements which are not only perceptible is a first condition, but also susceptible of being shown or exhibited or indicated to fact finders in the relevant context. This qualification is important, as I will tell you next. The value of probatory ostension can be stressed, if you want, philosophically, going back to the classical distinction between knowledge by acquaintance and knowledge by description, where knowledge by acquaintance, of course, is not knowledge by description. They are different kinds of knowledge. That distinction was made in particular by Bertrand Russell. When I say, for instance, I know Jordi, I claim to have a kind of knowledge which is different from the one I claim when I say, I know that Constantinople was taken by Mehmet the Conqueror in 1453. Of course, they are different kinds of knowledge. The first is knowledge by acquaintance. I have a personal knowledge of Jordi. And the second is just knowledge by description. I don't have a personal knowledge of Mehmet the Conqueror, nor was I there in 1453, of course. So, one thing is knowledge by acquaintance and the other is knowledge by description. And description is important, of course, for knowledge. The description form is crucial for the transmission and preservation of knowledge, of course. Typically, books contain knowledge by description. But description alone, that is my point here, is unable to tell you where truth is. Description alone is unable to tell you where truth is. Consider these descriptions of Jordi's breakfast this morning. I wasn't there, so I don't know what he had for. Where's Jordi? Okay. I don't know what he had for breakfast. Consider this description. On June 7, 2018, Jordi had for breakfast a croissant, a cup of tea, and some orange juice. Why not? Okay. Description 2, on June 7, etc., Jordi had for breakfast some sausages, black coffee, and a herring. Maybe less plausible, but you know, by description alone, you cannot tell which is the true one, of course. So, you can tell something more if you have knowledge by acquaintance. Were you there, you could have acquired by acquaintance some knowledge of Jordi's breakfast. In that very moment, you could have shown to someone else what Jordi was having. Later in time, you could have shown a picture of it in case you took one. Jordi didn't realize that, but a picture was taken, so we can show it later. And eventually, you could give a testimony about it if needed for some purpose. So acquaintance conditions are a crucial part of ostensive conditions, or if you want, perceptual knowledge with something is crucial here. Okay. Now, when we talk about ostension, the act of ostenting something, the first thing that likely comes to mind is pointing with one finger. That's the typical modality of ostension. Okay. This is the kind of ostension which is most natural when there is a material thing we want to draw someone else's attention to. Okay. This is pretty natural for babies. I mean, babies learn a lot of things by ostension, okay? But also adult life takes advantage from it. Consider that in many situations, including in many cases the legal context of fact-finding, pointing to something is easier, faster, and cheaper than giving a description of it, okay? Now, if you ask me, where's Jordi? And I have to answer you quickly. I said, he's there, okay? If I have to describe in detail where he is, I mean, it's more complex. I would say he's in row number 1, it's seat number, I don't know. So it's more complex, okay? But pointing is not the only modality of ostension. As George Herbert Mead, the pragmatist philosopher and social theorist, pointed out, we can accomplish an ostensive act in many different ways. For instance, he says, I'm quoting him, whether one points with his finger or points with the glance of the eye or motion of the head or the attitude of the body or by means of a vocal gesture in one language or another, it is indifferent, provided that it does call out the response that belongs to the thing which is indicated. Okay. So, provided that the context and background conditions make salient what we are interested in, Jordi, for instance, the glance of an eye may suffice. This calls for what I call a functional conception of ostension, where ostensive intention and response are connected by several ostensive modalities, such as pointing with one's finger, pointing with the glance of an eye, the motion of the head, or vocal gesture, etc. Now, in legal proceedings, very rarely a gesture suffices. True, in some special contexts, like for instance, a line-up identification procedure, a pointed finger may suffice, to indicate the guy who, shot the gun. But that is a kind of peculiar situation. In the central case of ostension in legal proceedings, the act is accompanied by words or statements uttered by the relevant party to the relevant hearer, before the relevant hearer in the relevant context. For instance, a material object is shown to the jury and the prosecutor explains that it was found in the defendant's apartment, for instance. Or a picture is shown to the jury and the defendant explains that it was taken just before the crime, etc., etc., etc. You can multiply the examples. Showing the thing, the picture or whatever, without saying a word would be interlocutory, to say the least. I mean, fact finders would wonder why the party behaves like that. It doesn't say a word, just shows a thing. Even if in exceptional circumstances a gesture might suffice, as I said. On the other hand, a statement describing something which is not shown, which is not exhibited, has less probatory value than the verbal act and the ostension of the thing, okay? So in the central case of ostension, fact finders perceive the thing, the evidentiary item, listen to what the party has to say about it, to the arguments about it, and finally make up their minds as to its probative value and whether the burden of proof is satisfied, etc. Now, just a part on the indexicality question now in the presentation. I don't have data that support my intuition, but I believe that probatory discourse, in fact-finding, is characterized by the use of indexicals and demonstratives much more than normative discourse. So this is a point, if you want, about the pragmatics of legal discourse. Pragmatics calls indexicals such words as I, you, here, now, words that refer to something without naming it, nor giving a description of it. Again, I, you, here, now. And it calls demonstratives the words that perform a similar function pointing to something, like this and that. these words, for instance. There's a distinction between demonstrative and indexicals, but I'm not going into that. I'm using indexicality in a broad sense. Now, what I think that is that evidence discourse as performed by the parties in a dispute is likely to be significantly characterized by the use of demonstratives and indexicals, by indexicality in general. Consider these simple examples of statements that are likely to be uttered by parties in a trial. Here is the object that was found, and the object is shown. That is the picture which was taken. Listen to this declaration. Listen to this declaration. Look at that letter. Look at that document. Okay, these are, indexical statements with an indexical part. And similarly, for linguistic interaction with witnesses. Did you see him? That is the person I saw run away from the house. Do you recognize this voice? The demonstrative, this is the relevant word here. And the answer might be, this is John's voice. Paul's is that. If you're not present in the context, well, you cannot distinguish the one from the other. But if you are in the context and this is said, you can, okay? Now, I think that this thesis captures some interesting, for me, features of juridical proof and fact-finding. But for some kinds of evidence, maybe the thesis is not, so interesting and so, is not that interesting and that relevant. For instance, you might critically object that the Ostension thesis fits with the presentation of material or tangible evidence, documents, pictures, and the like, but not the use of testimony and of expert testimony in particular. That might be an objection. So I've been told that by some colleagues that this is a critical case for my thesis. The argument would continue saying that witnesses do not show anything, they do not point at ostensible things, witnesses tell stories, or better, they report what they think they know about the litigated facts. Okay. So is this argument correct? Well, I'm not sure. I think there is a difference between showing a picture of the event with the ostension of the thing and listening to what a witness has to say about the same event. Of course, there are different means of proof. But notice the following aspects of the process of fact-finding. Witnesses, at least in adversarial context, must be present in the relevant context. They are brought in, so to say. They are on the stand, on the witness stand. They are there. And in a sense, they are exhibited to the fact-finders as sources of information. Okay? Secondly, they make statements and fact-finders listen to them. Listen to them. They hear the evidence in this case, in order to draw some probatory conclusion from the testimony. These are ostensive and perceptual aspects of fact-finding, I think. And they explain, justify to a certain extent, Jerome Frank's worries about testimony, if you want. Errors can affect not only the witness's own perception of the facts, their memory and the ways of reporting what they recall, but also the fact-finder's perception of what witnesses declare, let alone its interpretation and assessment. Okay. And in addition, of course, the witness demeanor, how the witness behaves while on the stand, is a significant part of the story, because fact-finders make up their minds, considering also how the witness behaves while being on the stand. Okay? And that's something that you can, perceive only if you are there. Now, concerning the expert testimony, I think that the situation is similar. While one might insist that the great bulk of what it relies upon is out-of-court expert knowledge. Technical or scientific expertise grows out of a mess of data, experiments, and tests that are run in labs, not, before fact-finders. Okay, this is true, of course, but we should not disregard the fact that experts are supposed to present fact-finders with their results, and they must do it in the relevant context and in the appropriate way defined by law.
They cannot simply email them, for instance. They cannot simply send an email to the juror and say, look, this is my result. I mean, cognitively speaking, it would be all right, but legally speaking, it's not. Okay? And they are also, they must be ready to answer also the critical questions about their results and the ways, they arrived at these results. Okay. So I think that the Ostension thesis fits anyway. Testimonial evidence. But there is another objection I'm going to address that is, I think, more serious for my thesis, which is the use of statistical evidence. That's a kind of evidence that, is kind of recalcitrant evidence for my thesis. When only statistical evidence is provided, the ostensive and perceptual aspects of it seem to be negligible. The proponent just needs to provide a number, so to say. Of course, not a number coming from nowhere, a statistical number, instead coming from reliable research and carving the right reference class, okay? And still, we know that it is somehow awkward to decide cases based only on naked statistical evidence. Why is this? Because our preferences go to ostensible evidence relating to the case in hand. Ostensible evidence relating to the case in hand, or case-specific evidence, if you want. The information that patients of a certain age range, in certain conditions, survive a given disease in a certain percentage of cases, if treated promptly, is not enough to decide a medical malpractice case, in my view. I mean, we want to learn more about the case in hand, about the patient's age and conditions, about the severity of the disease, about what was feasible in those very circumstances. And all this information does not come from statistics. I mean, it comes from ostensible evidence about the particular case. Finally, to address this kind of criticism, a more sophisticated way to address the critical observation consists in using Quine's distinction between direct and deferred ostension, direct and deferred. I'll be quick on this. There's a part on this matter in the paper. For instance, pointing at the gauge to indicate the reference of the word gauge is a form of direct ostension, according to Quine, and pointing to the gauge to indicate the gasoline level in the car is deferred ostension, okay? That's clear, I think, as an example. I think that similarly, there is a deferred ostension when we point at a recorded utterance from which a probatory conclusion can be drawn, or we point to some picture or video. And there is deferred ostension when we point at witnesses and their statements as sources of information. Now, to end this part of my presentation, a wonderful quote that I found in a work by Twining, Anderson, and Shan that you all know is the following. All evidential data, I'm quoting them, presented at trial, must be presented in a form that the triers of fact can perceive with their senses. Maybe it's trivial, but, well, it's true. Okay. This evidence consists of only two types, they say: testimonial assertions made by a witness from the witness stand, that is, oral statements the triers of fact can actually hear, and physical objects displayed to the triers of fact, or rarely other forms of evidential data that can be perceived, again I stress this perceptual dimension, by one or more of the senses. Fine, I completely agree with them. Now, to move on, since I love, logical structures, I'm trying to show here what the logical structure of the ostensive act is. I think it is this one. Basically, it is the idea that A shows B to C in context D to draw inference A. What do I mean by this? A is the party who exhibits the evidence. B is the evidentiary item, that's clear. C is the fact finder, to whom the evidence is shown, and D are the spatio-temporal coordinates defined by law, this is important,
And finally, E is the inference that the fact finder is expected to draw given the evidence, according to the giver of the evidence, that is A. Now, some comment on D. This is the relevant context. D is the relevant context. It is defined by law, by legal rules. That's the typical legal, that's the peculiar legal aspect of this kind of logical scheme or structure. The relevant context, for instance, a trial, is defined by the law, of course. Legal rules establish the relevant spatio-temporal coordinates, where, when, how, by whom, and to whom the evidence can be shown. This is a peculiar aspect of law. It's different from scientific research, and it's different from ordinary cognition, everyday cognition. Scientists, as well as historians, can choose their subject matter, etc., things that you know very well. Parties and fact-finders instead play their roles in a context which is highly regulated by the law. Players are bound by the rules in several respects, including spatio-temporal limitations, bans on certain kinds of evidence, legal criteria of assessment, standards of proof, etc. Imagine per absurdum, this is just an absurd state of affairs. Imagine that a lawyer showing a piece of evidence to the jury in an extra legal context like a Friday night party at the judge's place. Okay? Imagine also that the jurors draw the correct inference from it. Now, epistemically, that would be fine. There would be nothing wrong about that. Okay? But legally, it's not fine because D is missing, so the relevant context is missing, basically. However, notice that the above structure better fits certain kinds of proceedings than others. Ostensive acts take place when different actors collect the evidence and make decisions on it. Were the procedure inquisitorial, the same actor would play both roles and the need of ostension would evaporate, so to say. Public ostensive acts take place before independent and impartial, hopefully, fact-finders. The purely adversarial model of adjudication is the one that, in my view, maximizes the importance of probatory ostension, which is, not the case of inquisitorial proceedings. I'm going to the next thing. No, I'm still there. To move on, just what time is it? Okay. Sorry. Just a few words on what I call the principle of maximal proximity. This is a way of conceptualizing what I've been saying, considering, for instance, the following. What you prefer between 1, attending an interesting event yourself, 2, seeing a picture of it, and 3, listening to some testimony about it. Of course, you prefer the first. Unless you have some weird attachment to pictures or to narratives. And if you have some such weird attachment, you are expected to give it as a reason for preferring, the second or the third option. And similarly, if fact-finders can choose between a direct perception of the thing and a picture of it, it's reasonable for them to select the first option. If they can choose between a picture and the testimony, it's reasonable to prefer the picture, unless it is a very bad one, okay? So you can, if you share this intuition, if you think that they really apply to legal fact-finding, juridical fact-finding, we can conceptualize this with a principle that I call the principle of maximal proximity. It is the idea that, as far as possible, we should go as close as possible to the original truth. Original truth is an expression, a phrase that I take from Locke. There's a nice passage of Locke in his essay concerning human understanding, where he says that any testimony is referring to testimony. The farther off it is from the original truth, the less force and proof it has. So Locke's original truth is the correct account of the original relevant facts. And the farther we go from that, the less force a testimony has. That explains, the traditional ban on hearsay. I'm not going into that discussion, also because we know that today
several or many legal systems are rather liberal on hearsay, so there are some things that are in need of more discussion here. But I think that the intuitions I was referring to before can explain with this kind of principle, the idea that we should go, as I said, as close as we can to the original truth. For this minimizes error risk. I leave aside the issue of distribution risk, but the minimization of error risk is what this principle, hopefully achieves. This principle has some affinity with Stein's principle of maximal individualization. You can also consider it a version of the best evidence principle, but I don't have the time now to go into this. Let me conclude with a simple idea that both theses that I've been presenting here are necessary to an account of juridical evidence and proof. But there is a significant difference between the two. It's a difference in status, I think. I take the inference thesis to be correct regardless of the kind of evidence at stake. So it is analytically true of the word inference, of the word evidence, sorry. The Ostension thesis is different, I think. It's synthetically true of some kinds of inference. It's not true of any kind of inference and any kind of inference in the legal context. So remember what I said at the beginning. The process of juridical proof typically requires some ostensive act. I'm not going to say that it always requires that and that every kind of evidence, including statistical evidence, can be characterized in terms of this thesis, or at least it's not true that every kind of evidence can be the object of an ostension in the same sense. Okay. Nevertheless, this difference does not make one of the theses less important than the other, I think. This is my conclusion. If describing and explaining the world is important as much as analyzing our language and conceptual apparatus, both theses are equally important and necessary to an account of fact-finding, because they make sense of our usual ways of processing evidence and of deciding cases on their factual merits. Thank you.
Yeah, great. Thank you for that interesting talk. Do you have a... Do you need it?
I think I can understand Spanish.
If Spanish is good enough?
Yeah.
Okay, great.
I hope.
I'm going to argue next time let's take the jury back to the scene of the crime and let them see everything that exactly was there. So we'll take some questions now. You're way back there? Go right ahead.
Giovanni, al principio de tu presentación...
Giovanni, at the beginning of your presentation, when you explained what you understood by ostensive evidence, it reminded me of the way of understanding an evidence seen as a sign or as an, of the difference between things per se and to the extent that they relate to something and that somebody would interpret. But then in the second part of your presentation, I saw that that's not the way you see things, and that's not the aim of your thesis. And then I think I understood things better. So it's really a clarification. So up to what point does this relate to seeing evidence as a sign, or items of evidence as signs? You know about this much better than I do.
Very interesting question. I mean, I would need a deep discussion of semiotic issues and cognitive issues to respond to it. But basically, the idea is that when you have deferred ostension, to use that idea that I took from Quine, when you use deferred ostension, there is clearly a semiotic aspect. You point at something not because you are interested in what you are pointing to, but to a different thing, which is the object of the thing you are pointing, which is the sign indicating the other thing. That's deferred ostension. And that's
an interesting semiotical, process. When you point directly to the thing, and you have direct ostension, I'm not sure that signs are, relevant here. I mean, if I point to this pencil, you can perceive it, or if you have an idea of perception as an inferential process, maybe you can say that, well, you have some sense data that are signs of the object, so even in direct ostension there is a significant semiotic process. But for instance, some philosophers deny it. John Ostension, the philosopher, not the lawyer, claimed that it's absurd to say that I have signs of pencil before my eyes. I just perceive the pencil directly, the thing. I mean, it's bizarre to use this semiotic conceptual apparatus to explain the perception of a thing directly. So the crucial distinction here is between direct ostension and deferred one. Yeah.
So now we're going to take a question from that gentleman in the first row in the third seat, who I don't really want to point at, because that would be rude.
Bueno, gracias, Barbara, gracias.
Thank you, Barbara, and thank you, Giovanni. I have a question about your formulation of the principle of maximal proximity. I think it requires certain clarification, because the way you presented it, very possibly because of time constraints, I get the idea, well, you said, what would we rather have? See the object, or see the situation, or see the person, or see a picture of these, or listening to someone talking about this. And obviously, we'd all much rather have the first option. But this entails that we all see the same things, that we all agree in what we see when we see something. And I fear that this is not exactly so. When I see a stain or a mark on the skin of a friend of mine, I say, listen, you have a stain on your skin. But when that is seen by a dermatologist, he might see a disease. We don't see the same then. It depends on what we are interested in. We might have the preference of just seeing the stain. But depending on what our interest might be, well, then, of course, it's much better to have the testimonial knowledge of the physician who tells us that he has seen the disease. So then it's not obvious. The maximal proximity of the form, of the simple form, at least in the way you told us, is the best. So then I think that there should be some kind of more information, maybe?
There is a part of the paper where I try to address this worry, and it's, of course, true that in some cases, at least, ostension itself doesn't, it's not enough. It's not a sufficient condition for the purpose you have. Remember that I was saying that the conjunction of the thesis is the interesting thing here. I was saying that the process of juridical proof and fact-finding can be characterized by the conjunction of the two things, so the ostension thesis and the inference thesis. So, of course, as you said, if I want to, elaborate certain conclusions starting from, the thing that you were mentioning in your example, I need first to exhibit the thing, and then I need to make an argument. So, yeah, of course, you need both things. Evidence by itself, as I said in the beginning, proves nothing. I mean, if I just point to something without saying a word, I don't prove anything, unless the context is already such that everyone understands the point of pointing. Unless you need explicit arguments, reasons, etc., etc. No.
Okay, so we're way up there,
Sí,
right?
aquí. Bien, gracias. Tengo algunas dudas.
I have some doubts. I liked your paper a lot. First of all, I had understood that the ostension and inference thesis had been put forward and explained in the introduction as two opposing theses. Of course, later on, I realized that this is not the case, especially with this logical formulation. It would seem then that one, in a way, means to incorporate data that later on will have to go through inferential rules. But in any case, I got my kind of confusion back again, so to speak, when I see this kind of inferential thesis described as analytical, and Ostension seems to be described as synthetic. I would like to understand especially why analytical for the inferential thesis, that on the one hand. Sorry, just something, let me add something. Concerning the context, because that also posed some question marks. If, in a certain way, the benefit or the advantage of the ostension or the ostensive thesis comes because it establishes or allows the establishment of some kind of relationship with reality, well then, first of all, I thought that by context you meant the indexical context, but then it seems to be the context determined by certain legal regulations and standards. But then if this is so, I think that then you should be more accurate and define exactly what the relevant sense of the context is. I mean, is it really the idea that it's always a legal context? Because if it depends on what legal standards define, or is it a context that really depends on the way things are? And it depends on the way the world is, so to speak. Because if there is too much dependence on what is relevant in the legal rules, well, then I don't see so clearly this philosophical advantage of the ostensive thesis. I don't see why it should better explain or be more efficient to explain this relationship with the world. I don't know whether I've made myself clear.
Let me start by the first point, the analytic syntactic distinction about the two theses. My intuition is that if it's true that evidence by itself doesn't prove anything, it's also true that we need to elaborate some arguments, given the evidence. And so the inferential thesis is analytic as to the meaning of evidence in the legal context, in that, I mean, it is something which is used for, which is inferentially processed. That's a part, I think, of the meaning of evidence, at least in the legal context, but I think also in other contexts. Maybe it's disputable, but yeah, I have the impression that it is really a part of the meaning of the word or concept. It is not so for the ostension thesis, because if I think at, as I said, to statistical evidence, I don't see the ostensive dimension, at least in the same sense that I see it in the exhibition of a material object. Of course, the statistics, the statistical value or the relevant statistical data have to be exhibited in some loose way to the fact finders, but it's a different thing than exhibiting an object, a picture, or having the witness on the stand. So at least there is some difference in meaning between the ostension of one thing and the ostension of the other. That was the idea behind this difference in status of the thesis. About the context, your second point, well, I agree on your suggestion. I mean, I should work, I should make some additional work on this point, because you can understand the context as the indexical context, or in a different way, for instance, as the legal context, and that was the idea that I had in mind. When I said A shows B to C, in D I was, by D I was referring to the relevant legal context, the trial, a certain kind of legal proceeding where, rules define the context legally. So I was thinking at that at that thing, and in that context, there is an ostensive act, which is, the exhibition of a real thing to the fact finders. So there is a connection with the world, anyway, in this legal context.
There was someone in the middle over here who was pretty early on. Was that you? You were there, a hand up way before? Is that right? Okay, then I have here, there, and here.
Thank you. Do you think that we can apply the Ostension thesis for presumptions? Presumptions are logical inference that we consider one fact truth and the basis of unknown fact. Do you believe that we can apply the Ostension thesis for presumptions?
I don't see clearly what you have in mind. I mean, presumption is a way of, there are presumptive inferences that draw some conclusions, and so there are ways of, reaching conclusions and verdicts by means of inference. I don't think that presumption is a kind of evidence itself. It's rather something which pertains to the inferential part of what I was saying. So in that sense, I don't see the point of characterizing presumptions in terms of ostension. I mean, that's my first reaction, but maybe I have to think more about it.
Okay.
Sí, enhorabuena, Giovanni. Me parece que tu ponencia me ha interesado mucho.
Congratulations, Giovanni. It's been great, and you've also added something new in that one, well, that you should reflect on it. But I don't know whether in what you were saying, you were kind of stating that it's possible to have knowledge without inference, directly through perception. Because if that is what you are maintaining, I have doubts myself, because I would say that what perception gives us is sensorial data, full stop. And in order to be able to consider that as knowledge, it requires, first of all, that we eliminate the possibility that we have made a mistake in our perception. That is, that our senses are deceiving us in a way. And we didn't perceive correctly because of the lack of light, because everything happened very quickly, because it was just delusional. And this requires inferences. And then, secondly, I think that for such sensorial data to become knowledge, we also need to be sure that we have interpreted the data correctly, because we immediately interpret sensorial data. So I have to be sure that what I saw was that Peter was actually hitting John, and not simply that Peter was kind of playing at hitting John. And to interpret this, we need inference. So then I don't see how we can separate the idea of ostension from the idea of inference. I'd say rather that this knowledge by ostension is assuming certain inferences.
I'm not sure of your last point. I mean, I'm not sure that inference is involved in knowledge by acquaintance. I mean, when you have the perceptual knowledge of something, it's a kind of knowledge, or cognition if you want, that is different from knowledge by description or propositional knowledge. I was relying on the difference between knowledge by acquaintance and knowledge by description, as Russell put it, but you can say more or less the same thing in different words, for instance, distinguishing direct knowledge and propositional knowledge. And so knowledge of objects and knowledge of propositions, or knowledge of facts. So there are different kinds of knowledge, and I think that, well, in legal fact-finding, both occur. There are both. A juridical fact-finding is not only a purely descriptive thing in terms of knowledge by description only. It's also an effort of having some knowledge by way of acquaintance, by perception, of listening to the witnesses, looking at some material objects that are shown. So having some direct knowledge of things. Of course, then you need to elaborate inferences or arguments about them. You need both. I mean, we need both. We need both in our cognitive life. We need perception and inference. We need knowledge by acquaintance, direct, relation with the world, and we also need, conceptualization, description, inference, etc. So I don't think there is, an alternative here. If I gave you at the beginning the idea that there is an alternative, either you are a supporter of the inference thesis or a supporter of the Ostension thesis, that was the wrong impression. I mean, I think we need both. We need both. We need both in our cognitive life, ordinarily, for everyday cognition or knowledge, and we need both in trials and in legal fact-finding. And I think this is what typically happens. Maybe not always. In some cases there are exceptions. For instance, inquisitorial proceedings maybe are not characterized by ostension in the same way as adversarial proceedings are. That's possibly true. I mean, in general, typically we need both. That's the idea. And last thing, again, an epistemological discussion here would be needed because we should discuss about what perception is, what is the relation between perception and inference. You know, in the philosophy of perception, there are views according to which perception is inferential, others think that it's not. Well, it's a very complex debate, and you need also some, knowledge about the real functioning of the human brain, so you need some psychological...
Thank you.
Yeah.
So I want to know about perception. Can I ask a psychologist instead of a philosopher? Thank you.
It's not only a philosopher's, thing. Yeah.
Bueno, yo continúo un poco con cambio de idea.
Yeah, but let's go to a change of idea. I mean, the person speaking now has been excellent, and the person speaking before me was also great. Listen, on the one hand, I understand that knowledge, and even direct knowledge, or knowledge by acquaintance, always requires a certain judgment. Even when we see a table, we have to judge that this coincides with the memory we have of a table, or with the image that we have in our minds of a table. So the knowledge of things by acquaintance or by the perception alone, well, I understand that I'm not a specialist in epistemology, but it doesn't really exist as such, this knowledge that comes purely through the senses. But independently from this, I understand that as regards evidence and evidence in the legal context, it is always necessary to have what here has been termed as direct and deferred ostension, because in fact, or in truth, the evidence, the way I see it, consists precisely of the inference, not in what is ostentated, not in the object that is ostentated and shown, but rather in the inference that the fact finder carries out to link that object that is being made ostensive to the hypothesis, the factual hypothesis that must be confirmed. Because at the end of the day, the judge knows, but he or she knows in order to confirm or rule out certain hypotheses. And the judge will confirm or rule out hypotheses knowing other hypotheses that are contributed by the witness, by the document, whatever. So the judgment which has to be carried out by the judge to connect the ostentated object with the hypothesis that is to be confirmed or ruled out is the evidence. So yes, the object is ostentated, and that is the means of evidence, so to speak. The declaration of the witness is a means of evidence So it's the object known by acquaintance that's also an object of evidence. So then the judge, then and there, following with the example that Jordi was giving, well, the judge then has to say whether this is a pencil or this is just a bit of wood to confirm what is said by the defendant or the actor regarding the fact that this is a pencil. So then the judge must always, always, always carry out an inference. Precisely that judgment about the evidence. The evidence is not what is made ostensive, but the inference carried out by the judge between what is being made ostensive and the hypothesis to be confirmed or ruled out. This is my standpoint. I mean, it's up to you whether you want to accept it or not.
That's an interesting point. There are maybe a few things I would like to say about it. Well, first, I would like to avoid, if possible, terminological issues, terminological disputes. But I think that as, I don't know, in your, vocabulary, how things are exactly, but to my understanding, when Anglo-Americans use evidence, they also use it to refer to the objects. The evidentiary items is the idea of objects that are shown, presented, exhibited, indicated, and then you construct arguments out of them. Of course, you need arguments, you need judgments at the end, or verdicts if you want, but you also have, things of the real world which are there. They are shown. So, and they are called by, I think, many scholars evidence, in the sense of evidentiary items or pieces of evidence. In Italian, it's more tricky, maybe, because, prova in Italian has many meanings. We don't have the difference between evidence and proof, so semantically things are more complex in Italian. I'm not an expert of Spanish, so I cannot tell you about prueba semantically, but if you take the distinction between evidence and proof and uses like evidentiary items, pieces of evidence, etc., I think that this kind of, vocabulary refers to things, not only to arguments or inferences. Then the other point, you said there is no direct knowledge. I would be more prudent about it. There are ways of, having direct knowledge, I think. Let me start from the basic ones. Babies or very little children have knowledge of many things without having the concepts of them. They don't perform judgments, as you said, but they have knowledge of the world. Of course, they can recognize items, things that they are used to, to meet in their life. So they have knowledge. Of course, they have knowledge. Animals, non-human animals, have knowledge, or cognition, if you want, of the world, of their world, if you want, without having the capacity to formulate judgments and to, draw inferentially propositions from other propositions, etc. So there is, I think, a kind of direct knowledge of the world that we share with, other animals. And even in our mature adult life, it happens that we have some kind of knowledge that we are not able to translate into propositional terms. It happens. If I am an expert in some kind of music, I can distinguish, a certain instrument from another, and I can do that immediately. And that's the French horn, for instance. That's not the French horn; it's a different instrument. And then, if you ask me, how do you know? It's hard to say. I cannot give you a propositional answer to that, describing exactly the properties of the French horn or whatever. But as an expert in music, I can recognize the French horn and distinguish it from other instruments. That's a kind of knowledge that is possessed by us without a conceptual apparatus, without, we need some conceptual apparatus, but, without being able to perform the specific judgments about it.
So we have 2 minutes left, and we had two very enthusiastic.
Perdón que me...
I'm sorry, but really, I won't even go into the subject of knowledge because it takes us to philosophical terrain that I myself don't really master. So no, I won't do that. But I am interested in clarifying that, yes, indeed, the term evidence is a term that really responds or is linked to many different realities. And in fact, in the world of legal action, evidence is used to refer to the object that is made ostensive. You talk of evidence as well as the result of that, and you also use the word evidence for the designation of the activity that is developed. So yes, I agree, absolutely, totally and absolutely. But out of all these analogical meanings, because I mean, evidence is analogical, isn't it? Well, then it is necessary to precisely place the focal sense of the evidence. That is, out of all these senses and meanings, then, which is the one that encompasses all of them? Which is the meaning or the sense, the meaning, better said, that encompasses, includes all these realities that the term is referring to? And obviously, and of course, on the basis of my criterion, I repeat, it's my personal view, the meaning that encompasses everything is the evidence judgment.
I'd like to leave because it's 20 after 7. Please be our guest. I'd like to thank our speaker, and he can continue speaking if he so chooses. Have a good evening, everyone.